Hi there, this is John Massey, attorney at law, and today I want to talk with you about a very important legal document, the power of attorney. A power of attorney is a document that grants someone else the authority to act on your behalf with respect to legal, financial, and other personal matters. There's also something called a healthcare power of attorney, which may be referred to differently depending on what state you live in, but we'll save the discussion regarding that document for a later date. For now, I want to give you an overview of why people have powers of attorney, some of the different types of powers of attorney that may exist, as well as some of the details with respect to the powers in a power of attorney, so that you have some general but practical information regarding this tool. First, the reason why most people tend to utilize powers of attorney, in my experience for estate planning purposes, is that they need to make sure someone can act on their behalf if they become incapacitated, and they don't want a court to get involved with that decision. So assuming that a person wants a power of attorney for this purpose, what kinds of powers of attorney exist? Well, oftentimes a power of attorney is intended to be durable, which means that it survives incapacity. It can be immediate, meaning that it goes into effect the second that it's signed, or it can also be springing, in that it springs into effect once some event has transpired or some condition has occurred. It can also be general or limited as well. For example, if someone just wants another person to be able to access investment account information and records, but doesn't want them to be able to transact business with the account, they might use a limited power of attorney for this purpose. All that being stated, the kinds of powers of attorney that are available to you and how the power of attorney will be drafted is a function of state law. So you have to be sure to talk with an estate planning attorney in your state before making any assumptions. Additionally, the power of attorney should include powers that you want exercised, as well as potentially parameters for exercising certain powers. The point here is that if you're not comfortable with granting your agent under the power of attorney a particular power, you should discuss it with your attorney and determine whether it's the power itself that is the problem or just the lack of parameters around the power. It may be that the power that you're concerned about can be exercised under certain circumstances without it being a problem, but not in others. Your estate planning attorney can work with you to structure the power in a way that's desirable to you, or at least advise you as to whether you shouldn't have the power in there in the first place. So, that's all for today, folks, and I will be back in the near future with some more general information about legal issues. And in the meantime, take care, and I look forward to speaking with you soon.